Hi everyone, good afternoon. Welcome back to another session. My name is Tomi Ogunleye. This session is brought to you by Accent Nominees. And today's topic is the implications of data privacy laws on business operations in Nigeria. As we all know, the world's most valuable asset is no longer oil, but is now data. Data privacy is becoming the most important thing in the 21st century. Data protection is the process of safeguarding important information from corruption, compromise, loss. Data privacy concern has become a big thing due to the increase in device. Most times you want to access a platform or your social media and then they are telling you to supply your personal information, your personal data, just for you to access the platform or the social media platform. So as we all know that data is very important. Most times you lose your phone and then you say it's the thing on the phone that you are after, not the phone itself. It's because you are interested in the data itself, the things that your phone contains. So there even most data privacy concern has become a very big thing due to the increase in devices. Customers are connecting everything to their internet. Even their households are connecting their devices to the internet. Thus, the concern around privacy breaches is increasing with time. You as a business owner or entrepreneur or startups or companies should take your customers' data privacy seriously. The right of data privacy and protection is an internationally guaranteed right which enjoys protection universally. So just the way this data enjoys privacy and protection in Nigeria, it also enjoys protection in other countries, UK, Canada, the US, and so forth. Typically, internet subscribers and social media users are required to provide personal data and sensitive information to facilitate access and use of these platforms. As I said earlier, most times you are required to submit your details just to access even any app you are trying to use now. They will request for your Gmail, your address, your phone number. Can you snap a picture? Let's see you. Most times they ask for your signature. So most customers actually are very wary of this, that supply my details. Most people don't even trust some applications because of this data they will be supplying. Almost all transactions are conducted online and then they require the release of some sorts of personal data. Protecting data from compromise and ensuring that data privacy are other key components of data protection. However, where there are no laws to enforce this event of breach, the value of those rights are lost. So what I'm saying is that if there are no laws to actually protect these rights, then the value of the rights is actually lost. So in order for you to uphold the sanctity of this right, most countries put in place a form of regulation mechanism just to enforce or guarantee that these rights are not breached. Nigeria is also not left out in this global community of data privacy and data protection regulation. There are certain relevant legislation that impact in data protection and data privacy under the Nigerian laws. And of course, number one on the list is the 1999 Constitution of the Federal Republic of Nigeria. The 1999 Constitution is always the ground norms for other laws. Most laws, when they are trying to ratify and domesticate them, everything in those laws have to align with what is in the Constitution. So the Constitution is actually backing the right to privacy, which is Section 37 of the 1999 Constitution. The 1999 Constitution, Section 37, protects the right of citizens to their privacy, the privacy of their homes, correspondence, telephone conversations, telegraphic communication. Data privacy and protection are thus extension of a citizen's constitutional right. Every citizen have a right of privacy, and infringing on this right is unconstitutional, illegal, and you could be sued for breach of this right. So as a business owner, as an entrepreneur, as a startup, as a company, it will be advisable that you do not breach any of these rights, especially Section 37 of the 1999 Constitution. So the second on the list that I have is the NITDA regulation, which is the National Information Technology Development Agency. In Nigeria, while there are several legislations or laws that several legislations and laws containing ancillary provisions which seeks to protect data privacy, the most comprehensive statutory instrument for this purpose is the NITDA Act, which is the National Information Technology Development Agency. They are committed to implementing the National Digital Economy Policy for Digital Nigeria. They are empowered. They issue guidelines to cater electronic governance, monitor the use of data exchange. So what the NITDA does is that they provide guidelines, they cater electronic governance, they monitor the use of electronic data exchange. And the third on the list is the FOIA, which is the Freedom of Information Act 2011. The FOIA, the Freedom of Information Act 2011. So the purpose of the FOIA is to make public records and information held by government agencies more freely accessible by the public. I'm sure you're wondering, I'm talking about data privacy, why am I talking about FOIA? However, FOIA also specifically makes an exception with respect to personal records and information and matters concerning personal privacy, which it all goes back to privacy. In this regard, Section 14 of FOIA limits government agencies from disclosing personal information of citizens unless you grant your consent or the information is publicly available. If your information is publicly available, of course, but in a situation whereby your consent is not obtained, and then they go forward, I will go ahead to publish this, then you could sue the person, or they could sue you if you are the one publishing it without the consent of the other party. So the fourth one on the list is the Cyber Crimes Prohibition Prevention Act 2015. That is the CPPA. The fundamental purpose of the CCPA is to establish a framework for prohibition, prevention, detection, prosecution, punishment of cybercrimes in Nigeria. CCPA, it imposes an obligation on mobile networks, computers, communication service providers to store and retain subscriber information for a period of 2 years. Significantly, it requires such service providers to provide importance. They provide accord to importance of an individual's right to privacy as it is enshrined in the 1999 Constitution. As you can see, this law actually backs the Section 37 of the 1999 Constitution. So basically, all these laws align with one another. One cannot breach the other. So this law, CPPA, is actually backing Section 37 of the Constitution, which is right to privacy. The fifth on the list is the Nigerian Communications Commission, the NCC regulation. I'm sure we all know this. So the NCC regulation 9 of the NCC regulation is also backed. It also backed the right that is guaranteed in Section 37, as I mentioned earlier, and subject to any guidelines issued by the NCC or a licensee. Any subscriber whose personal information is stored in the central database and is entitled to request updates, to have the data kept confidential, not to have subscriber information duplicated except prescribed by the NCC Act or where you give your consent. Also, licensees are required to utilize subscribers' information in accordance to the law. Likewise, licensees and other named parties are required not to retain biometrics of any subscriber after transmission to the central database, meaning after they've transmitted most of the information to the central database, they have no right to retain any of your information. Even after 2 years, they have no right to retain any of your information. Most times, there are some things we do as business owners, as startups, as companies. We have our customers' information, and someone will just come up to you and ask you, and fast, you're already like, you're already, how will I put it, you're already mentioning these customers' details. You don't need to do that, because doing this, you are basically infringing on the customer's rights, which is against Section 37, against FOIA, against the NCC regulations. So the thing you need to obtain the customer's consent if you should disclose this data to the other party. Just imagine, I'm sure you guys already know the case going about one of our celebrities, where the other party sued him based on breach of right to privacy, and then she was awarded compensation of 5 million naira. So in a situation like this, if you are the one disclosing this information, this data to the other party, you could be sued. Sometimes it does not only attract penalty, it attracts criminal, how will I put it, it could attract sentence depending on what the law says. So most times we have fines, we have a specific period like imprisonment. So it will be advisable if you don't disclose. And sometimes when customers notice that you disclose this information, they don't trust you. And one of the reasons why people do business with you is because they trust you. And one of the reasons why you want people to do business with you is because you want them to trust you. If they don't trust you, then how would your business move? Like, how would you make profit? Like, it goes a long way. Trust actually goes a long way in business relationship. So the sixth one on the list is the NDPR, which is the Nigerian Data Protection Regulation. It is one of the most comprehensive attempts to tackle data protection and privacy in Nigeria. And it is one of the laws that we're discussing today. So the NDPR applies to citizens whether you live in Nigeria or outside of Nigeria, as long as you are a citizen of Nigeria. This law will actually apply to you. This act is essential to ensure security of personal and sensitive information which are entered on different platforms and are protected and kept safe. The act identifies personal information as your name, your address, your email, your photo, your bank details, which is most times BVN, post on social media, and so forth and so forth. The objective of this NDPR are to safeguard the right of natural person to data privacy, the foster safe handling of transactions that involves exchange of personal data, and prevent acts of manipulation relating to personal data, and ensure that Nigerian businesses remain competitive in the international market through adoption of necessary laws. Any person or business that is found that breaches this right of privacy or data, anybody that is caught or business that is found to be in breach of this privacy right of any data is subject under the NDPR to criminal liability, and it also attracts specified fines, as I said earlier. So it could not be only fines, it could be imprisonment, and I'm sure you would want to avoid that. So it would be right for you to go through the right way and the right means. So in conclusion, what I'm saying is that data is a very valuable currency in this 21st century. Most of the things we do it online. But most times, if you don't have data, you see the way you just like, there's nothing for me to do. Everything we do is always on the internet. And then with the laws I've mentioned above, with the laws I just mentioned, there is a transformational landscape that offers protection and privacy for the personal data of people engaging in business. Not only business, it could be anything. The right to privacy is guaranteed. Everybody, whether you're in business or not, just that you want people to trust you. And then when there's when you don't protect your customers' privacy, then most people won't patronize you. Most people don't like to do business with you. Business owners, entrepreneurs, companies, and startups should note that the compliance with these laws will not only aid protecting the personal data, will not only aid protecting, it's not only protecting the personal data of your customer, but it would also keep you in business, as I said earlier. And it will also help you, and it will improve and maintain the brand value of your organization. As I said, your reputation is at stake, and I'm sure you don't want that. So just do things the way you should do. In fact, the law is saying that you need to protect the right of your not only customers, but you know what I mean. Right to privacy, everybody deserves one, and it is internationally, universally guaranteed. Nigeria is also one of the countries that guarantee these rights. So compliance will give an organization a competitive advantage over its contemporaries, and it will also prevent loss of revenue for businesses. Thank you, and I would urge you to watch our previous section where we spoke about regulatory framework. Kindly check, and then if you are just joining us, I would like it if you could give us a thumbs up. Thank you. Join us this time next week. God bless.